everybody. Today we're shifting gears to a topic that comes up more often than people realize in New York real estate: religious entities buying, selling, or refinancing property. Churches, synagogues, mosques, religious corporations, and non-for-profits. Here's the thing: religious entities are not treated like regular individuals or LLCs under New York law. And this is where deals can and do fall apart if you don't know the rules. Do religious entities need to register with the New York Department of State? Yes, in most cases. If a religious organization is incorporated in New York, it is typically formed under the Religious Corporations Law or not-for-profit corporation law, and it must be properly registered and in good standing with the New York Department of State. From a title perspective, that means we must verify the exact legal name of the entity, its corporate status, active, dissolved, merged, that the entity has the legal authority to own or convey real property. The name on the deed doesn't perfectly match the corporate record. That's a red flag. Do religious entities need Attorney General approval? This is the big one. And the answer is often yes. In New York, when a religious or not-for-profit entity sells, transfers, or sometimes mortgages real property, the transaction may require approval from the New York State Attorney General, and in some cases, court approval as well. Why? Because the law is designed to protect charitable and religious assets and ensure they're being used for their intended purpose. From a title standpoint, this means we must confirm whether Attorney General consent is required. We must review corporate resolutions very carefully. We must confirm that the signing parties are properly authorized trustees or officers, and we must ensure all statutory approvals are obtained before closing. No approval. When approval is required, then we can't insure the title. Here's where people get into trouble. Some common mistakes that we see are assuming a pastor, rabbi, or imam can sign a loan, using outdated corporate resolutions, skipping Attorney General approval to save time, discovering after contract that court approval is required. And once you're under contract, delays can cost real money. So the takeaway here is, if you're dealing with a religious entity in New York real estate, this is not a DIY situation. You need a knowledgeable title company, an experienced real estate attorney, and a clear understanding of statutory approval requirements. At Exclusive Land Services, we flag these issues early, coordinate with counsel, and make sure your transaction is clean, compliant, and fully insurable before you get to the closing table. Because in New York, title is not just paperwork, it's protection. We're protecting what matters, because when it comes to religious and not for-profit real estate, you don't want surprises, delays, or missed approvals. You want to close with clarity and confidence. That's all for today. If you're representing a religious organization or involved in a transaction that requires special approvals, please visit www.exclusivelandservices.com and place your order today. Until next time, stay confident, stay informed, and remember, when the rules are different, experience makes all the difference. I'm Luba, and this was Title Talk.